Jon Guze is Director of Legal Studies for the Locke Foundation. He recently wrote about this debate over what's called risk assessment tools. He joins us now to talk about it. Jon, welcome back to the show.
Thank you, Donna.
What got you interested in this subject?
Well, I saw this letter, this open letter that was published by a group of academics, most of them from Harvard, at MIT, and I think one or two from Columbia, one or two from the West Coast, I think Stanford, but mostly from Harvard and MIT, really criticizing the use of these so-called risk assessment tools. These are computer programs that help a judge assess the likelihood that a criminal defendant is going to abscond and not appear at trial, or perhaps commit another crime while they're, if they're not held until trial.
These academics believe that this is a bad approach?
They think it's inherently unfair, and they don't want to see any courts using these tools. That's right.
What does the tool base its assessment on?
Well, there's actually several of them around, but I think the one that's most commonly used, and the only one I'm aware that we're using here in North Carolina, bases their assessment on prior convictions, whether or not the person is employed, whether or not they have a fixed place of abode, whether they have family in the area, things like that.
That sounds like it is an attempt to be fair and to take maybe some subjectivity out of the decision as to whether someone sits in jail or is allowed to post bail to get out?
Well, there's no question in my mind that the people who develop these tools and the people who are using them, mostly really on a rather experimental basis, all are well motivated. That's exactly what they want. They want to be fair. The problem that they're addressing here is a serious and it's a real problem. When somebody's arrested and they appear before a judge or magistrate, there's already probable cause to believe they've committed at least one crime. And so it's reasonable to worry about whether or not they're going to appear at trial if you release them. And it's also reasonable to worry about whether or not they're going to commit more crimes between the time of their arrest and the time of trial. But on the other hand, in this country, we have the presumption of innocence. Those people are presumed to be innocent until they've been convicted by a jury of their peers. So we don't want to, it's not fair to hold, and we have due process. You know, you can't deprive somebody of their liberty without due process of law. So, and on top of all that, it's expensive. I mean, holding people in jail until trial costs the state money, costs taxpayers money, and it's terrible for those people. They can lose their jobs. They can, it can disrupt their family relationships. So it makes sense in all kinds of ways not to hold anybody unless there's a very good reason. But on the other hand, sometimes there is a good reason. So it's a tough decision, and judges and magistrates have to make that decision over and over again every day without much information and without much time. The idea of developing tools to help them makes a lot of sense.
Well, it sounds like it makes sense. So why would the critics be concerned about the types of data that is going into the assessment tool?
Well, they make a lot of criticisms in this letter, some of which don't even apply to many of the risk assessment tools, and particularly the ones we use here in North Carolina. But I think their major concern is this. Even with the use of these risk assessment tools, we see racial disparities in the outcomes. That is to say, a disproportionate number of African Americans end up being held until trial compared to some other racial and ethnic groups. That's what they don't like. And they blame this on what they consider it bias, but it isn't really bias in the way we usually use that word. The problem is that when you look at things like employment, when you look at things like prior arrest history, there's disparities there. And unless we can get rid of those disparities, any kind of a fair system that treats everybody impartially there's going to be disparities.
So really the question becomes, when did the disparity originate?
And why?
And why? So that was the view of the critics of this tool. These academics released this letter. Then in response, there were 3 North Carolina academics who responded. Tell us about that.
Well, this is the kind of thing I love to see, and I see it all the time. When people in some parts of the country get really worked up, self-righteous, moral indignation, people in North Carolina often take a step back and calmly point out what's more reasonable. And that's what we see here. So Brandon Garrett at Duke and his colleague Cynthia Rudin, also a professor at NCSU, Sarah Demaray, she's an expert on these risk assessment tools. She's been working with this for years. Brandon is a criminal justice expert at Duke Law School, and Cynthia, I think, is a computer scientist at Duke. They just pointed out that let's be sensible here. Let's not just run to some extreme. There's problems with the pretrial system as it stands. Nobody disagrees with that. It certainly doesn't. We shouldn't rule out of hand the use of computer tools to help make this process better and more fair. And they pointed out some of the specific claims that the critics make that weren't true, but more importantly, they pointed out things like this. If you're worried about bias in the system, you aren't going to eliminate it by eliminating computer-aided tools. When a judge or a magistrate is looking at a criminal defendant, that judge or magistrate knows what race that criminal defendant is. If there's bias, you're not going to get rid of it by eliminating these tools. On the contrary, these tools at least provide some kind of objectivity.
Jon, you are an attorney yourself, and so you have had a lot of contact over the years in one way or another with the legal and criminal justice system in North Carolina. Where do you come down on this?
I think these tools are worth exploring. We should be trying them, and I think it really is a good idea to see what we can do to improve our pretrial system. We don't want people being held unnecessarily, but we don't want people out there putting the public at risk either. Anything we can do to try to make that system work better is worth trying. As long as we just don't do it blithely, we have to constantly evaluate how well it's working while we're trying it.
You know, there's been a lot of writing. You've done some, and others have done some as well, on this question that seems to me to cross ideological and political lines about the issue of a free society and what happens when someone has been alleged to have committed a crime, but they have not been convicted of a crime, and so they're innocent until proven guilty. But yet there are some people who may not have the financial resources to post bail, to get out until their trial, and may end up sitting in jail simply because they didn't have the money. How do we address that in a free society?
Well, that's the $100 question or the $100,000 question here, and nobody has a really good answer. Money bail was originally instituted as a way to avoid people being forced to stay in jail from the time they're arrested until the time they face trial. So there were some good motivations there, but there are problems with money bail, and you've pointed out the most important one, which is that some people can afford to post bail and others can't. As a result, sometimes you get people who can post bail, they go out, and they do commit another crime. So we don't want to have that happen. If somebody's a risk to the public, they should be held regardless of how wealthy they are.